So you're already dealing with all that comes with the death of a loved one, and you get a letter in the mail that says that your accidental death insurance claim has been denied based on an intoxication exclusion. Well, you're not alone. This happens to many people. The intoxication exclusion is often something that the insurance company tries to rely on to deny claims and not pay you the money that you deserve under your accidental death insurance policy. Automobile accidents, bad falls, and drownings are some of the most common types of accidents where we see insurance companies raise the intoxication exclusion as a defense. Well, one thing to keep in mind if you've been denied a claim based on an intoxication exclusion, do not give up. The insurance companies are often wrong, and you can prove them wrong either on appeal or in court if they deny your appeal. Hi, I'm Price McNamara. I spent years representing the insurance companies before quitting that to use the knowledge I gained there to represent people against insurance companies when they deny insurance claims. Insurance claim denials are 100% what we do in this office, and we handle these claims every day. We'll go through the steps that we take to appeal a denied claim that we call our Win My Benefits process. Step one in this process we call gather. In that step, we gather all evidence known to exist that we can look at that could help potentially prove the insurance company wrong in denying your claim. It begins with a request to the insurance company that they produce their entire claim file to you as a claimant and beneficiary. They're required to give you the file by law, and if they don't give it to you timely within 30 days, they incur penalties. You should make this request in writing so that it's of record, and when you get that claim file, you need to go through every page, and it will have things like toxicology reports, police reports, ambulance reports, first responder reports, witness statements perhaps, and it will shed light on what the insurance company's reasoning was, what experts it may have hired to look at the facts and support their conclusion that the intoxication exclusion applies to your case. And it'll also include the insurance policy and any denial letters or prior versions of the denial letter before they sent it to you. So you need to get all this evidence together so you can see what the insurance company is relying on to support their denial and what evidence might be in that same record that will support your position that the denial based on the intoxication exclusion was wrong. Step two in our Win My Benefits process is to organize. And what I mean by that is, when you get the claim file from the insurance company, you're going to find that it's a disorganized mess. There's going to be duplicate pages, there's going to be blank pages, and it might be anywhere from several hundred to several thousand pages of records. What you need to do is take that file, organize it, tab it, make basically an index of it, sequentially page number the entire file, put it into a computer program that lets the text be searchable, and that way you're going to have sort of a roadmap of exactly what exists in that record, and it's going to be useful for you when you make your argument appealing the denial or later making your argument to the court, where you can in a very organized fashion cite to a specific case number within that big file where the court or the insurance company during your appeal can follow exactly what you're talking about and look at the documentary evidence very easily as they go through your argument. The third step we follow in our Win My Benefits process is to analyze. And by that I mean, first you read the denial letter, you see exactly what the insurance company is claiming the reason for your denial is. And then you look at the insurance policy and you look at exactly how that intoxication exclusion reads, because there can be very minor differences in intoxication exclusions from one policy to another that have dramatic impact on whether or not the exclusion applies to a particular set of facts. They're written very differently from policy to policy. And for instance, Some policies require for the exclusion to apply that the intoxication had to actually cause the death itself, not just cause the accident that led to injuries that were fatal, but that the alcohol itself caused the death, and as in an alcohol toxicity poisoning. Well, you have cases where that's how the exclusion reads, but the insurance company treats it as if alcohol or intoxication simply causing the accident, where the injuries from the accident caused the death, are excluded under the policy. But under that type of exclusion, it would not be excluded unless the alcohol itself caused the death. Now, another way that exclusions are written are to only require that the intoxication caused the accident, and that the injuries from the accident caused the death. And the exclusion is written in a way that if the intoxication just caused the accident, the policy excludes coverage, even though the intoxication, the alcohol itself, did not cause the death. But even in those cases, the insurance company has to prove that the intoxication actually caused the accident. So, for instance, a person can be intoxicated and have a blood level above the legal limit of alcohol that equates to intoxication, yet they get in an accident where intoxication had nothing to do with the accident. For example, if a person who had too many drinks and was legally intoxicated is driving and has the green traffic signal and gets T-boned by another car that had the red traffic signal, although the driver, the accident death victim, was intoxicated, obviously the intoxication didn't cause the accident. It was the fault of the other driver who ran the red light. So under an exclusion that only requires that the intoxication caused the accident, there still can be arguments that the intoxication did not, in fact, cause the accident, even if everyone agrees that the accident death victim was intoxicated. Then there's a third type of intoxication exclusion that only requires that the person who died was intoxicated at the time of the accident. That kind of exclusion doesn't require any causal connection between the intoxication and the accident. In other words, the example I gave before, where an intoxicated driver runs a green light and the other driver at fault runs the red light, we know that the alcohol did not cause that accident. It was the fault of the other driver. However, if the exclusion is written to exclude coverage based on intoxication simply when the accident happens, regardless of whether it caused the accident, the insurance company can still get away with excluding the coverage under those circumstances. It all depends, and it's very subject to the exact wording of the exclusion that's in your policy, which may be very different than exclusions written in other policies. The other part of step 3, analyzing, is to look at the case law that's out there, because there's many cases on the books where judges have interpreted language of policy exclusions, and you look for ones that are similar to your particular policy exclusion and see how the judge interpreted that, and try to find case law that is similar to your case, similar exclusion language, and where the court ruled that the exclusion did not apply to the facts of that case. So again, we analyze the strengths that we see for our case in the documents that we've gathered. We look at the weaknesses in our case where we need to improve on the evidence to support our case. And then we move to the next step. Okay, so step 4 in the Win My Benefits process is build. And by that I mean, you look at what evidence you've already analyzed and you decide what evidence might there be out there that can support your position in the case and refute the insurance company's position. This may include statements from witnesses that were never taken from the insurance company that can talk about the behavior of your loved one shortly before your loved one's death. It can be missing medical records that existed between the time of the accident and when your loved one dies. Or it may include hiring an expert of your own choosing, perhaps a toxicologist, to look at all the facts and the testing, the toxicology results, the autopsy if there's any, and see if he or she might disagree with the insurance company's position on the intoxication. So oftentimes these arguments are very technical and require an expert with the type of education to actually give an opinion that stands up in court about whether or not test results are faulty, whether or not the test results showed a false positive, or whether other facts indicate that the person in question was not intoxicated at the time of the accident. Step 5 in the Win My Benefits process is to execute. And by that I mean you take all of the evidence that was in the original claim file, the insurance policy exclusion provision, the denial letter reasons, and then the evidence that you've built or created and added to what the insurance company didn't have. That might include the report from an expert you hired, it might include other witness statements, it might include other medical records. It really just depends from case to case. But you take that and the case law that you've reviewed and you weave that all together into your best argument, factually and legally, why the insurance company was wrong in their denial, why you are right and entitled to benefits, and you submit that to the insurance company, you wait for them to rule on the appeal, and sometimes they'll grant the appeal if you convince them that they're going to lose if they take it to court. If they deny the appeal, your work was not for nothing, because now you can use all the work you put into this, all the evidence that you've built up, and that's going to help you try to convince a judge in federal court that they were wrong in continuing to deny the claim. So final thoughts. It's really impossible to generalize exactly how you would build evidence to fight a claim denial under an intoxication exclusion, because the facts are so different. The insurance policy's provisions and exclusions are so different from case to case. And I would say the best thing to do is before you create your appeal, before you talk to the adjuster, before you do anything, you can download our free book. It's on this website, or you can get it at winmybenefits.com. And it's our book, How to Win Your Accidental Death and Dismemberment Denial Appeal. Read that. It's full of information. It's makes you aware of the traps and the tricks that the insurance company will try to play with you on the way and how to avoid those. And it gives you a broad overview of how the process works in general, the timing of it, the deadlines, and other important things that you need to know if you're going to handle one of these claims. If you'd like to talk, better yet, give us a call, and we're happy to talk to you about your claim. It's free of charge, no cost to evaluate your denial letter, and we love helping people with these. We'd love to help you any way we can, and I appreciate you listening to this. I hope it was helpful. Have a great day.